I'm going to start to ask some of these questions. And, Gary, if you could do your best. These are questions mostly from our agents. What's your most succinct definition of procuring cause? If you could put it into a couple of sentences.
It figures, Rob, that you would start out with probably one of the more complex questions I have to deal with. Procuring cause in the eyes of the courts in New Jersey is defined as the person or entity that begins an unbroken chain of events that leads to the closing of a real estate transaction. Now, what does that mean? Well, I'll give you an example that I use all the time. If I get up on a Sunday morning and I go put my open house sign out, and a buyer who's working with some other company's licensee as a buyer's agent drives by right after I put the sign out, sees it, says, wonder what this is all about, drives over to my open house, goes in, takes a look, and then calls their agent up, and their agent writes up an offer. Most people say, well, the buyer's agent's obviously the procuring cause. They wrote up the contract. And the answer is no, they're not. The courts would say the contract never would have gotten written if Gary Large hadn't got his fat self out there and put that sign on the corner of the street that directed the buyer in. Wow. So it's a complicated subject, and it requires, my goodness, when we do professional standards hearings, if you were to see the instructions, the pro standards officer, our pro standards officer, Nina Kaiser, has to give the panel to consider. There's about 18 different questions that they have to answer regarding procuring cause. Because here's another example. If there's a break in the chain, the courts in New Jersey say, well, why did that break occur? Was it interference by another agent? Was it abandonment by the original agent? So just the fact that there's a break in the chain doesn't necessarily change who is or isn't procuring cause.
If a buyer does come and say, hey, Gary, I want to see your home, but I am working with an agent.
Well, again, I have options as the agent at that open house. I could say that's fine, but I would probably say this. I'd say, well, let me ask you a question before we go any further. Did your agent tell you to come to this open house? Are they the reason why you're here? And if they say yes, then I'm going to respect the fact that that person is the procuring cause. These buyers wouldn't be here if they hadn't directed them. So I'm going to show them the open house, and then I'm going to call the other agent and say, hey, you ought to get with your buyers that came to my open house. But if the buyers were to say, no, I was driving by and saw your sign, I'm going to say, hey, that's fine. You can work with that agent. I'm not going to say this to them because I don't want to do anything to jeopardize the transaction. That's an important concept too. But I'm going to, in my mind, say, fine, then we'll let them buy it through their agent. And then when we get to the closing, we just won't pay the agent. And we'll tell the agent, look, if you think you're procuring cause, file an arbitration request.
Perfect. Thank you.
So you kind of answered this question. Somebody showing up at an open house does not constitute procuring cause, for the record. What if a buyer is merely shown a home by an agent and decides that they don't like working with that agent? How does the procuring cause rule work? Because a lot of times the agent that shows the house feels a sense of entitlement, and I don't know how you would address that one.
Again, I wouldn't. A professional standards hearing panel would if it got to an arbitration request. But again, you as a buyer can work with any agent you want. But if the reason you were at that open house was the actions of that agent you don't like and don't want to work with, that doesn't change the fact that in the courts, they're considered procuring cause. So they get paid the commission. So if you want your agent that you want to work with paid, you're going to have to pay them.
Now, I thought that there was a concept where they had to come to the price of where it was for the procuring cause. Is that a myth?
Well, I'm not sure what you mean, Rob, about come to the price. In other words,
I think he means meeting of the minds.
Right. If a buyer comes to an open house and makes an offer with their own agent, even though the open house agent is the procuring cause, and the negotiations go nowhere, there's no meeting of the minds, then there's no issue of procuring cause.
So Gary, here's a case where an agent called me up and said that they'd seen a property with an agent, they're interested in that property. They asked the agent to provide comps. They asked them to give them some guidance on how they can make an offer. And they said the agent was ill-prepared or not competent to answer those questions. So they decided they don't want to work with them. Are they still the procuring cause?
Not necessarily. The facts, as you just presented them now, indicate that even though they may have got the chain started, they weren't able to keep it going. And in fact, because of their lack of knowledge or their unprofessionalism or whatever it may have been that caused the buyer to say, I need to go to somebody else, would in effect be considered by the hearing panel in an arbitration request as the reason why the chain broke. And they would say, unfortunately, that the agent they went to that picked the chain up and started it going again is now procuring cause.
Fantastic. Now, we normally have a pretty interactive group here. I want to see if anybody has any questions before we kind of shift here on this.
Okay.
Harry, you are so masterful in answering. Nobody has a question.
Either that or they're particularly bored.
One or the other, but we'll go with the first part there, Gary.
Sorry, Rob. It's Colleen from Florida. Florida's procuring cause is a little different. In the state of Florida, welcome to the Wild Wild West. The state says whoever writes the contract. However, if the agent is a member of the association, then it falls under their guidance. And certainly the procuring cause would be the same as you were discussing, Gary.
Yeah, Colleen, that's a great point, and thanks for raising it. There's two different types of states out there as to how to handle agency. New Jersey is a common law state, which means there's very little written rules and guidance regarding agency. Most of the rules are established by the Superior Court decisions that are made in lawsuits. Florida is one of many statutory agency states, meaning Florida's Real Estate Commission took the time years ago to write an agency rule book. And so Colleen's absolutely right. They've defined procuring cause differently than the courts in New Jersey define it. They say it's the person who writes the contract. So I have a license in Florida, so I'm familiar with their concepts down there. They have a system I wish we had in New Jersey because it's much easier to operate in that system, because you have a rule book that tells you how you're supposed to do things.
But the lawyers like New Jersey better because everything's litigated.
Exactly, Rob. And then it makes me happy because it gives me a job, because I'm the guy that has to go into all the court records and look up how courts have ruled to kind of figure out what they want us to do in terms of agency or procuring cause or whatever. Because again, there's no rule book I can go to. The commission regulations, the only paragraph that deals with agency in the commission regulations is paragraph A in 6.4. That basically is, they stole that paragraph out of the Code of Ethics of the National Association of Realtors back in the 1920s. The Code of Ethics Article 1 says that when we're acting as agents, we put the interests of our client above all others, including our own. That's primary, but we also treat everybody honestly. Well, that's almost word for word what the rule is in the commission regulations, section 6.4, paragraph A. But that's the only reference to agency in the 150 pages of regulations. The rest of the time, I got to go look into court records and see what superior court decisions have been made in litigation involving the issues that I'm asked about.
Okay, so Gary, during the presentation, I may periodically mute everybody. If you could just unmute yourself when we have background noise, I'll let you know. I'm going to do that now.
Thank you, Rob. I asked you.
Okay, if you could unmute yourself there, Gary. We're going to go on to another question.
Go ahead.
Can a landlord of a two-family house who lives in one of the units refuse to rent to a tenant who has a support animal?
Yes. There are two exemptions to the New Jersey law against discrimination's fair housing component, and one is what you just described. You need to be very careful because there's a lot of people that know that there are 4 exemptions in the federal law, but none of them apply in New Jersey because they involve not only rental but sale. New Jersey's 2 exemptions are only for rentals, and it's what you just described. If you have a two-family, and only a two-family, again, the federal exemption goes up to 4, so it gets confusing, but if you own a two-family and half of that two-family is your primary residence, then the law says you have every right to say to someone who's blind and comes to your place to rent the other half with a seeing eye dog, sorry, even though it's illegal for me to discriminate against you because of your blindness and the need for a service dog, because I live in the other half of this two-family, the law allows me to do that, so I will not let you rent. Now, you have to be careful with the exemptions, because way back in 1968, the United States Supreme Court, in a case called Jones versus Mayer, interpreted the old Civil Rights Act of 1866 as prohibiting discrimination against people on the basis of their race or color under any circumstances, including legally written exemptions in federal and state laws. So you could not say to an African-American couple, I live in this half of the house, you're not going to rent the other half because you're African-Americans. That would be a violation of the Jones versus Mayer decision, because you're discriminating on the basis of race or color. But all the others, like familial status, you own half a two-family house and the young couple shows up with 4, over-energetic kids, you can say, sorry, I'm not renting to you because I don't need that kind of excitement in my life because I live on the other half. So it's perfectly legal to use that exemption for familial status. Now, let me just point out the other exemption. The second exemption is the exact same thing. It just refers to the rental of a room or rooms or an apartment in your primary home.
Fantastic. Now,
and one last caution, Rob. If you're going to use the exemption, you own a two-family and live in half of it, you're not allowed to use the services of a realtor to list the other half for rent, and you're not allowed to advertise your intent to use the exemption. You couldn't say half a two-family home for rent, no children.
Gotcha. So you answered my question without me having to ask. So we're not allowed to participate in those discriminatory practices that
Correct.
are allowed by law.
Correct.
Can I interject something here?
Sure.
Ask a question. Sorry. Speaking about rental, Section 8, what about Section 8? People that want to rent Section 8, a lot of the agents don't want to work with them because, it's hard to get them into a property. So how do you handle someone that comes into a Section 8? Sorry.
Ron, that's my next question. Can landlords refuse to accept tenants solely based on public assistance? And I think I know the answer, but I want to hear it from the guru.
Let's see what you think the answer is, Mr. Lazard.
My thought is the answer is you're not allowed to discriminate solely on where the income comes from.
Exactly. New Jersey has a protected class that's entitled source of legal income. And so if a person's receiving vouchers from the federal government under Section 8, they're receiving any kind of state, county, or local assistance, the landlord, number one, must consider that as the resources they're going to use to pay the rent, and or they're not allowed to say, well, because you're Section 8 and I might have to make some changes to the house or to upgrade it or repair it or to meet the requirements of HUD, I'm just not going to rent to you. Patently illegal. And in fact, last October, when the Real Estate Commission did the continuing education workshop for instructors, those of us who have instructors licenses have to do CE every 2 years to renew our instructor license. They had the new head of the Division of Civil Rights on, and I can tell you, he is on a tear because he just said they're seeing more of that than just about anything else. And he said he's had it. So they're just throwing the book at people that they catch doing that.
Hey, Gary, what about based on credit? Let's say these Section 8 or anyone based on credit.
Credit is considered by both the federal law and the state law as an objective criteria. So if it's applied consistently to every prospect, there's no problem with that whatsoever. And the landlord can say, look, if you don't have at least a 620 or a 700 or whatever number they want to pick, as long as it's applied consistently to every prospect, that's perfectly legal.
Fantastic. Anybody from our group have any additional questions on this?
Yeah, just one more. So if someone wants to rent Section 8, and you ask them about their credit score, but you don't have it disclosed in your listing, a credit score limit or a credit score restriction, you can just say, if they say to you, well, my credit score is 580, but I have a voucher, will the owner accept it? How do you handle that? So do you have to have a disclosure in your listing?
Well, I'm not 99% certain, but I don't think that there's anything that requires a landlord through their agent to list what criteria they're going to use in the listing. So my answer to that part of the question would be no. And even if they have an established number in their mind, again, sellers can change their mind, but they need to be careful because the key word here is consistency. You know, if it's an African-American couple or if it's a Jewish couple and they say, well, for you guys, it's got to be 720. But then a Caucasian couple comes along and says, well, I really only have 680, but I've got this voucher. And all right, you're good, because in reality, what's driving the landlord is the racial discrimination that they want to exercise. You'd be treading on very thin ice. But the landlord could change their mind and they could consider somebody with less of a credit rating and say, okay, the fact that you get money from the federal government regularly offsets my concern about your credit.
So Gary, if the housing voucher is for the entire payment, just to be clear, they can still consider credit.
Yes.
Okay, because we get that question a lot, like, oh, but if they don't have to pay anything, can they look at credit? And I think that the answer to that is yes, and it just needs to be consistent.
Yeah, and that's really the key.
So,
is they pretty much
I'm sorry, Gary. You have to be very careful in the state of Florida. They do send, he's laughing, he knows. They do send out testers for Section 8. And in Florida, the credit score, like you say, Gary, needs to be consistent.
Okay.
So, Rob,
it's all taken because one of the things the new director of the division said to us last October is they are beefing up the budget they're using for testers. The New Jersey Real Estate, the New Jersey Division of Civil Rights absolutely uses testers. These are people that are trained to pose as prospective tenants, prospective buyers. They operate in teams. So there's one member of the team that would be in a non-protected class, a white couple. And then there's the other member of the team that's in a protected class, whether it's someone with a physical handicap or someone with children or whatever it may be. So, and they're really good at what they do. And where there's inconsistencies, that's where you're going to get a knock on your door from an investigator from the division.
Okay.
so Gary, I just wanted to get clarity. As the listing agent for a rental, when the owner says, I do not want Section 8, our reply to that owner should be,
You're in violation of the New Jersey law against discrimination. And if you get reported to the division, you're going to suffer some serious financial consequences.
got it.
And Gary,
That's how it is.
and Gary,
That's how it is in Florida, too.
we would be prohibited from working with somebody with that bias, right?
Well, prohibited, yeah, because it's illegal. But if you go ahead and do it anyway, now you've just broken the law along with them.
So essentially, as your new broker of record, we're prohibited from doing that.
I have a question, please.
Sure.
So what about, can they say, because I was represented as Section 8 tenant at one point, and the listing agent told me, well, they have to have 3 months rent. One of the months could be the voucher, but then they still have to have have the other two as income. Can they say that?
It's a really good question, Lisa. And that's one that I would hesitate to say. I mean, they are considering the voucher. In my opinion, but I'll confirm this and get it back to Rob so he can pass along to you. In other words, the landlord's saying, look, I want X number. Let's just pick a number. I want you to have $1,000 a month in income for me to consider you qualified to rent my property. I see that you get 500 from Section 8. You have to show me you have an additional 500 income resources, and then I'll rent you. I think that would be okay, but I will call the division and ask them, and I'll pass the answer back to Rob to pass to you guys.
Fantastic.
What would be wrong, Lisa, would be for them to say, I need $1,000 a month from income, and I don't give a hoots about that voucher. I don't want anything to do with Section 8. That would be illegal.
Hi, this is Nadia from Jersey. I thought it was prohibited for a landlord to accept additional monies outside the voucher.
I don't know whether it is or it isn't, Nadia. I said I'm going to try and find out. I'm going to ask out around and find out and give that answer back to Rob to pass along to you.
Nadia, I think the question, I think that's a separate question. So Gary, the question that you were addressing before was regarding income. Nadia is saying that if somebody has a voucher for $1,000 for housing, the landlord can't make a side deal to say, you got to pay me $1,200, $200 on the side that housing doesn't know about. I think that that would be violating some contracts that you're signing in order to do it.
Well, yeah. In other words, if the landlord said, okay, fine, you're getting $1,000 from the federal government under Section 8, but I want an additional $200 a month in rent from you, but someone who wasn't using Section 8, he didn't require an addition, or she didn't, or they didn't require an additional $200. Yeah, to me, that would be an illegal act. They're discriminating against the person on the basis of their source of income.
But there's yet another layer, but I think Nadia's question was like, if they're renting it for $1,200, somebody has a voucher for $1,000, can they sign the voucher for $1,000 and then take $200 on the side? The answer to that would be no, because that would be violating their housing contract with whoever the provider is.
Well, again, I don't know the ins and outs of Section 8. If Section 8 has a rule that prohibits them from doing that, then the answer to the question would be, you're absolutely right.
Yes.
That doesn't make any sense. If the owner is asking for $1,200 a month and the voucher's $1,000, why can't he tell the tenant, you have to pay me the extra $200 a month?
So Ron, in New Jersey, like when they sign a contract with housing, it says that that's the full payment. The tenant's not paying anything else as part of the voucher, right? Because they're qualified based upon, you know, an income criteria. So I'm gonna move on to another topic. Gary, lead paint. There's been some changes on lead paint and testing and multifamilies and state and municipal regulations. Can you shed a little bit of light on, you know, what your knowledge of that is and what we should be aware of?
I wish I could, Rob, but I'm going to say at the moment I haven't finished going through all the material that I got sent by the New Jersey Realtors on the changes that have been made to the lead paint paste requirement, lead-based paint hazard requirement.
When were those changes put forth?
Relatively recently. I don't know, remember exactly, but it sticks in my mind that I got a package of information about it back in the fall,
So
late fall of last year. So it's relatively recently.
In the past 6 to 9 months. So
right.
maybe you can share with Rob Garber and I, you know, what your assessment of that is once it's been completed.
I would be happy to do that. Seller
Disclosures, and should there be disclosures on rental properties?
New Jersey is not one of the states that requires disclosure by the seller for sure, and certainly not from the landlord. I guess my response, my opinion, and you know, you'd have to decide to what degree you value my opinion. I don't think there'd be any harm if a landlord was willing to do so, for the landlord to prepare a disclosure statement for the tenant to take a look at. But there's definitely no requirement that a landlord does that, nor does a seller ever have to do that.
Gotcha. Now, from my perspective, Gary, if a seller is like unwilling to prepare a seller's disclosure on the state form, the authorized form, you know, we need to have a red or a yellow flag rise and say, well, why is this that they're not willing to do it? And I believe you might not know the answer, you probably do, but if you don't have that seller's disclosure, you lose safe harbor from treble damages in New Jersey courts.
You do in Florida.
The reason the seller property condition disclosure statement was adopted in New Jersey years ago was because of the New Jersey Realtors Association, who, as they do, look after us on the political field. And they fought with the state because they wanted a way to protect our members from being subject to the potential of treble damages in a fraud lawsuit because of information that was provided about the condition of the property that was inaccurate. So what we were able to get put into law, into the Consumer Fraud Act, was that if we use the form, if we do not participate in any way in the preparation of the form, if we sign and acknowledge that we did not participate in any preparation of the form, and in signing we acknowledge that we made a visual inspection to the best of our untrained ability to see that the information on the form matches what we can see, then it is the law. Consumer Fraud Act does not allow a judge to assess treble punitive damages if there's a fraud case and we lose it.
Okay, and then the other critical piece here, you know, luckily most of us will never have a E&O claim, but if there is a claim where there is an assertion of treble damages, they are often by statute awarded attorney's fees as well. I don't know if you're aware of that, Gary.
Oh yeah. Mm-hmm.
Now, Barry had shared with us at our regional leadership meeting for RE/MAX owners that there was a new change in the statute that also provides us protection for innocently passing along information that was provided to us, which is huge. And I was particularly involved in a case where we had gotten an email. Gary, this is interesting for you. We got an email from a township official saying that it had a 3-bedroom septic, and we passed that along to the buyer. And it turns out that it was designed as a 2-bedroom septic, and the town had immunity, and we were being threatened with treble damages and attorney fees. So that, in my understanding, has been changed. Thank you to the lobby of the New Jersey Realtor Association, I believe.
Yeah, it actually, the language was already there. It just was beefed up. It basically, it said in so many words that if the information we provided was from a quote unquote expert, that we would not suffer the danger of treble damages and attorney's fees. What they did was they broadened the definition, and it described the kinds of experts that we can recommend. And if they screw up, it's not our fault. There's no way we would be expected to know what a zoning officer knows, or a building inspector knows, or a home inspector, or a plumber. So that's what they did. They beefed up the language.
Yep. And if you have a client that is unwilling to prepare a seller's disclosure, I would just be really careful, because I do believe that a seller's disclosure also protects the homeowner or the seller, as well as it protects, you know, a buyer, because a lot of times people don't even read those things, and you can say, hey, everything was properly disclosed.
Yeah, the last broker I worked for, Rob, his policy was, if your seller prospects won't sign the disclosure, don't bother bringing in the listing, because I won't accept it.
Yeah, I think that's, you know, in this environment where prices have gone up quickly and buyers are limiting their inspections, you know, I think we need to be really, really, you know, careful. And our leadership team probably needs to take a look at whether we're going to move in that same direction, Gary. I appreciate that. Can a buyer who only wants to work with a listing agent hire one of us as a consultant, either for an hourly fee or a flat fee to be paid by the buyer at time of closing? What's your thoughts on that?
Well, again, it's fraught with confusion in terms of the wording. So you're saying, can a buyer who's being represented by a broker as a buyer's agent hire someone else as a consultant to assist them in the transaction? Do I understand the question properly?
No. So we had this question posed to us. When people are losing out on lots of offers, Gary, they're saying, I only want to work with a listing agent because I believe I have a better shot at getting that accepted. But I want to hire you to help me identify the properties. Then I go to the listing agent because my belief is that I'm more likely to get accepted with the listing agent making both ends of the deal.
So essentially, can I as a buyer work through the listing agent and also hire myself someone to provide me buyer representation, essentially?
Yes.
And the answer to that question is that would be fine for the buyer to hire someone, as long as the person they hired was not in the same company as the licensee who was the listing agent, because the commission prohibits us from being paid by both sides of the same transaction when we're acting as dual agents. So if one of your agents was the listing agent and the buyer wanted to hire someone else from your company as their consultant, that would not work because the seller essentially would have to pay for the consultant's fee in addition to the real estate commission.
Got you.
But they could hire someone from Coldwell Banker or Keller Williams to be their buyer consultant agent and pay them whatever fee that that person wanted to be paid as their buyer representative.
Is there a particular accounting or peril with somebody paying an agent by the hour, even if it's paid through the brokerage, in your opinion?
As long as it's being paid through the broker, there are areas of the country where I'm told, I've not experienced it directly, but particularly buyer's agents will bill hourly.
Okay, fantastic.
We'd be rich if we did that.
I know the answer to this, and I don't want this to go on for a long time, but can you just broadly address the issues regarding love letters and the consequences of either seeing one as a listing agent, what you do with it, or preparing one or forwarding one if a buyer insists?
Yeah, and before I do, I noticed somebody had popped a little, I don't know how it works, but a little question popped up asking me if what I was saying about the seller disclosure statement was that you shouldn't sit there with the seller and help them fill it out. And that's absolutely what I mean. What you should do is hand them the form and say, you need to have this completed and returned to me. If you have any questions, ask your attorney, because you're not to participate in the preparation of that document. And it gets dangerous if you're sitting there while they are, because how are you going to defend yourself when the seller says, well, Gary was sitting right there and he was telling me what to put in the different blanks. That was just the kind of testimony I heard in a case that I was hired to be an expert witness on just last month, where the charge was being made that the realtor had basically filled out the seller disclosure statement.
Fantastic.
Right, but getting back to your question, say it again, Rob.
So
the love letters.
Love letters, in terms of a buyer insisting on it, or if one is presented to us as a listing agent, how do we address that?
Well, again, this is something that really you as the broker of record have to kind of decide to what degree you want to take on the potential liability. I have said for years when I taught, before it was even an issue now, the way it is, that those things are dangerous. Those love letters are dangerous, particularly when they want to include pictures of their families and such. And I used to say in the ABR course, long before NAR issued its opinion, that if it were me, I wouldn't be involved in those things in any way, shape, or form. If the buyer insists on doing one, I would say to the buyer, do it, put it in an envelope, seal it, and I'll hand it to whoever the listing agent tells me to hand it to, because the listing agent might say, I don't want any part of this any more than you do, so give it to my seller's attorney. And that's
why would that be a violation? I don't understand.
Well, because suppose that when they open up the love letter, there's two of them, and one shows this lovely Christian couple at their Christmas tree, and the other shows this African-American couple celebrating Kwanzaa, and the seller goes, well, I love Christmas, then I'm going with this buyer. And that's the danger that NAR says that we put ourselves in when we participate in these things, is that we, usually not intentionally, but it's just the way it is, open up the possibility that the seller will make the decision on an illegal basis that violates the fair housing laws. And the liability is big enough that NAR says you shouldn't be involved in these in any way, shape, or form. Interestingly enough, you may not have heard, but the state of Oregon actually passed a law making these illegal. And immediately some consumer advocacy group on behalf of buyers filed a lawsuit against the state. And believe it or not, the Oregon Supreme Court turned that decision over and said to prevent buyers from using those tools would be a violation of their First Amendment right of free speech. So I don't think you'll ever see them outlawed, but I do think that NAR will continue to tell its members, from our perspective, it's far safer for you to say to a buyer that wants to do that, that's on you. I don't want anything to do with it. You give me an envelope and I'll take it to whoever the listing agent tells me to take it to. But then there are even some brokers that say we don't even want to receive it. You mail it to the seller or do whatever you have to do to get it to the seller.
So on that same vein, Gary, I imagine it would be ill-advised if you sent out a picture of a couple looking to buy a home in a particular area and you did a mailing saying these people are looking to buy, that would put us in the same risk.
Absolutely.
Okay. Thank you for that. If an agent is contacted by a homeowner seller whose house is currently listed with another broker and is not happy and asked to take over the listing, what options does an agent have?
If another broker's client, the seller,
Yes.
initiates a conversation with a different company's broker and or licensee about listing the property, the code of ethics, in fact, bear with me a second here. But this one is one I don't, but I'll give it to you.
Are you saying that if the seller has a listing agent that he wants to list it, but he hasn't listed yet, that if someone solicits that seller, that is a violation? Is that what you're asking?
No. So Ron, the question is, somebody has their home listed, right? They're not satisfied with the result from their listing. Most commonly, you list the house 4 doors down, and the seller comes to you and says, "You sold your house in 2 days. I'm not happy with my agent. Can you help me? I have 4 months left on my contract," and I turn it over to Gary.
What we're talking about is found in the Code of Ethics, Article 16, Standard of Practice 16.6, which says this: when realtors are contacted by the client of another realtor regarding the creation of an exclusive relationship to provide the same type of service, and that realtor has not directly or indirectly initiated such discussions, they may discuss the terms upon which they might enter into a future agreement, or alternatively, they may enter into an agreement which becomes effective upon the expiration of any existing agreement. So unless they can get an unconditional release from their current listing agent, the best you could do in that circumstance is take a ride over to the house, do your listing presentation, have them sign a listing contract that takes effect at 12:01 a.m. on the day after the listing that they're currently under expires, and then sit back and wait until it becomes your listing.
So that would be a post-dated listing agreement,
Correct.
and those are allowed.
Right in Standard of Practice 16.6, as long as you didn't initiate the conversation with the other realtor's client.
So
It's the same thing in Florida, with the caveat that you cannot tell them that they need to cancel the other listing.
Agreed, Colleen.
you can't coach them. Now, Gary, if we go out and take a listing, we meet a homeowner today, and we're going to put it on in 14 days from now, and we don't want to use it coming soon. We date the listing agreement today's date and say effective on the 20th of April.
Yeah, that's a question I've heard before, and last time I remember speaking about it, I talked to Jeff Dollinger, and I can't remember exactly what he said, but I think in a nutshell, what he said was that essentially that's just another form of post-dating, which means that the listing that you take is not enforceable in court as to the commission until the date it becomes effective occurs. So it really doesn't provide you much protection.
So would a better alternative to that be to sign a full listing and have a waiver of broker cooperation till the live date?
Yeah, you could do it that way, yes.
That's an important distinction that we have because, I guess the post-dated listing is unenforceable by law, right? And, you put your pot out there, you start doing work, somebody else solicits it. I'm familiar with a case where we were vulnerable and we had to accept far, far less than we believe we were entitled to in that scenario.
Yeah, and you need to be careful with the waiver of broker cooperation, if I can just go down that path for 2 seconds. I am sure most of you are familiar that in the Real Estate Commission regulations in section 6.4, the broker waiver, the waiver of broker cooperation is actually printed. It's a printed document. And whenever a document's printed in the statute, it's called the minimum. In other words, you have to use it exactly as it is written and intended by the law. Understand that when you have a seller that is saying, I want no broker cooperation and signing that waiver, then no other realtor or their licensee, no other broker or their licensee should under any circumstances ever be showing that house or negotiating offers. Basically, what you have to tell other realtors who have buyers who discover the listing, this is an exclusive listing. We have a waiver of broker cooperation. If your buyer wants to see it, we'd be happy to have you refer them to us and we'll pay you a referral fee. But our seller does not want to work with any other broker than us. And that's a full waiver of cooperation. The regulations also allow, it's actually paragraph F2 of that section 6.4, for the seller to relieve us of some of the requirements in the regulations in writing if they want to. For example, the rule says we're supposed to place all of our listings in the MLS within 48 hours. Well, a seller could send us written instructions and say, I don't want my listing in MLS. I want the whole world seeing all the pictures of the inside of my house and that kind of stuff. I don't mind other brokers cooperating. So if you want to put a sign out and another broker sees the sign and you want to let them show, that's fine. Well, that's different than a waiver of broker cooperation, because then it's perfectly fine for other brokers to be in that listing, because what your seller is saying is, I don't want MLS exposure, but I would love cooperation from other brokers. But once they sign that waiver of broker cooperation, nobody, and I mean nobody, but the listing broker and their licensee should ever be in that house showing it, negotiating on that house, because that's the intent of that form. And the commission, and I have noticed, is aware that that form tends to be misused, where someone will have it signed and they'll say to one of their competitors, sorry, the seller doesn't want anybody but our people showing it. And then another competitor colleague who's kind of like a buddy, they'll say, oh no, you can go in, you can show it, I trust you. And that's called selective cooperation, and that can get you in trouble with the commission.
Now, are these primarily NAR rules that are driving this, or state law?
No, this is your New Jersey Real Estate Commission regulations found in NJAC 11:5, so they are law, civil law.
So Gary, let me ask you a question for a second. I had an agent come to me that their client had gone to an open house that the listing agent was with another brokerage, and they told this buyer that the seller only wants to work with someone from their brokerage.
And that would be a legitimate instruction, Robert, if that seller has signed a waiver of broker cooperation and you as the buyer's agent have a right to request a copy of that. And the commission says the listing agent has to provide it.
Okay, but if they had not?
If they've not signed a waiver of cooperation and the listing agent or listing broker is doing that at their own initiative, they're violating the commission's regulation requiring that we cooperate with all those brokers.
So as an agent, I could actually ask the listing agent for a copy of the waiver of broker cooperation then?
Yes, you can. And if they refuse to show it to you, then that becomes, what I would suggest is a reportable offense. I'd file a complaint with the commission.
Fantastic. So
sorry, Rob, even when the seller says, for example, I don't want it in the MLS, but I'm happy to cooperate with other brokers, those instructions, according to the commission, are supposed to be in writing. And in fact, the rule says they're to be in writing. They're to be made an addendum to the listing contract, and they're to be made available for inspection by any buyer or buyer's agent who requests them. So not to do that is a violation of the regulations.
And I have had this one question, which I do believe I know the answer to. If somebody had a bad experience with a particular firm or agent, they can exclude that in that cooperation rule, right?
Yeah, if there's a justifiable reason why the seller does not want to cooperate with a particular broker, and that reason is not an illegal reason. Again, Rob, I don't want anybody from XYZ company because I know the broker that owns that company is an African American and I don't want to do business with African American businesses.
Yeah, no,
That'd be illegal. I mean, you can't
Right.
do that. But I don't want anybody from XYZ Realty because last time around I had an experience where one of their agents had a drug problem and stole some of my prescription medicines, and I don't want anything to do with them being in my house. That's a legitimate reason to say sorry.
So Gary, some of it's my belief that some agents have shared that some of our competing brokerages are encouraging and saying, hey, we need to find a way so that we can share the listings only with our own company, and are taking initiatives to do that. What's your opinion on that, if you have one?
Do, and I would say that those brokers are, in my humble opinion, absolutely violating the underlying foundational ethical and legal principle of our business, which says that we put the interests of our client ahead of all others, including our own. For me as a broker to try and initiate a program where we only want our people to be able to fill these listings, we're denying the seller the full exposure.
Everybody's muted. You have to unmute yourself again, Gary.
That would mean that that broker's denying their seller client the full exposure that might yield a better offer than their own company would come up with. So I think it's an inherently bad thing to do. It's really us shooting ourselves in the foot, those people that are doing it. We're trying to take ourselves back to the 1940s where the MLSs didn't exist. We never took exclusive listings. We always took open listings because that's the only thing the sellers would give us. And everybody would have in their pocket all these different open listings, hoping they could keep it secret from each other so they could sell it and get the commission before somebody else did. And why anybody would want to go back to those old days is beyond me. But that's what we're trying to do to ourselves. And it's greed. I get it. They want to make the whole commission, but you know what? It's not in the best interest of their client.
So Gary, what about if I'm going to be practical and say maybe it's not a greed issue, but there are some agents in the industry that aren't good at following up and responding. So I have a client that wants to see a property. I reach out to a particular agent through showing time or whatever the instructions are. I don't get an answer for 4 days. What are my options there?
Again, there is a rule. It's 11:5 6.4 paragraph F, and I believe it's subparagraph 3 that says that the listing agent cannot place any unreasonable restrictions on the ability of cooperating brokers to show the house. So if you're having trouble getting your buyer into the house for whatever reason, that would be my first phone call to the real estate commission or an email. And an investigator is going to pick up the phone and they're going to call the listing agent and they're going to say, what's going on here? And if they don't like what they hear, they're going to come out. And if they come out and they don't like what they see, they're going to invite this person down to the commission offices in Trenton for a hearing. And that person's probably going to suffer at minimum a fine, or they could lose their license under a suspension or even a revocation.
I mean, does the state have the resources to investigate? Like, I want to show a house on Saturday and it's Wednesday and I'm not getting any response. You know, is that the best practice to do to try to prevent the behavior?
I'll answer it this way, Robert. For many years, the investigative department of the commission has been underfunded and struggling to keep up with the demands of their work. I happen to be very, very dear friends with the senior inspector, and I know I probably shouldn't be telling tales out of school, but they've just received he's just received permission from the executive director. They're adding about 15 inspectors over the next 18 months. That's going to bring them up to probably about 30 inspectors. We were as low as 8 inspectors at one point. Still means that we far out, there's 72,000 of us out there practicing real estate with a license, and whatever the population of the state, there's buyers and building owners that are doing things illegal. So they're outnumbered, and pretty much they can only react to complaints that are filed. But I assure you, if you file a complaint, it's very easy to do. You just go to the commission's website and you scroll down to the bottom of the homepage and you'll see a link that says contact us. And in the middle of that page you come to is a box that says for consumer assistance, and you click on that, and there's a form that you fill out to file a complaint. And every complaint has to be addressed by an investigator, at least by phone. That's just required by law. So you'll at least get the investigator to make a phone call and say, what's going on here? Why can't Rob and his company get into your listing? And again, if they don't like what they hear, then they come out and visit you, and they don't like what they see, you end up in front of the commissioners. There's 8 of them in a hearing, and you can end up being fined or lose your license.
Hey, Gary, I would also say to that agent who's pursuing this venue to be sure that they have all and any documentation, text, phone calls, showing request, all up the wazoo. They have to have that ready.
And
Without a doubt.
And I would also piggyback on that, saying before you go rogue filing complaints with the commission, talk to your broker manager of your office before you do that, because maybe there's a way that it can be resolved broker to broker where you don't alienate the client. Because if you do this, it's not likely that that's going to help your client get in that house. By the time the investigation gets done, the house is probably sold.
On point, Rob, because
So,
when an agent calls me, that's what I do. I call the other broker and I say, hey, can you
right.
help us?
So please go, see your office leadership on trying to find a alternative resolution. That's kind of a last case. How, Gary, this is a best practice question for you. How should an agent or a brokerage proceed when they're presenting an offer on their own listing and there are multiple cooperative offers being presented, in your opinion? I know this is not a rule, it's kind of a best practice.
Well, it's a best practice, and it also has some ethical implications, because the first issue you've got to deal with is talking to your seller at the time you list the property and asking them some basic questions about what you want me to do as your agent if we do experience a situation where we have multiple offers. Because the code of ethics makes it clear it's the seller who drives that decision, not you, the listing agent. So the seller might say, look, if we get a situation where an offer comes in, offer A, and then offer B, we're told is coming in, as seller, I don't want you to tell offer A about offer B because I don't want to scare offer A away. So if the individual with offer B asks about any other offers, your response will be, I'm not at liberty to say. And the seller has the right to direct us to do that. Or the seller could say, hey, if I have offer A at 400,000 and you tell me offer B is coming in, I give you permission and approval to tell offer B, we already have an offer in, it's for 400,000 and you better be at that or bigger, because higher, because we don't want to waste our time on something less. So the seller can direct that we reveal that there's another offer, we can reveal the terms of the offer, and if the offer B buyer's agent smart and knows the code of ethics and knows that if he asks, we have to say whether offer A came from the actual listing agent, someone in the listing agent's company, or another cooperative firm. So we're only required to provide that information when we're asked, if the seller's allowed us to say anything about other offers as well. It's complicated. If the seller says, we've got offer A, you tell me offer B is coming in, I want them to know about offer A, but offer B is coming in from someone in your company, Rob, so it's a dual agency situation. You can't follow the seller's instructions then. You have to get the buyer B permission to reveal their offer to the buyer in offer A, because it's a dual agency situation. So it gets complex pretty quickly. I mean, I wish I could give you a best practices. I think, if it were me and I was a broker or a salesperson in today's environment with all these multiple bids, I think I would want to, try to have as little to do with it as I could, to the extent that I would probably talk to the seller and say, look, one of your options would be to authorize me to tell all these offers to put them in an envelope at your best and final, and we'll deliver all those envelopes to the seller's attorney, and then you and the attorney can have a discussion as to which ones you want to pursue.
Okay.
But I know that's not always feasible.
So when you're
Stephen,
representing,
hold on. I have a question, Rob. It's Ellen.
Hold on.
sorry, it's Ellen. When you had said a couple of weeks ago that you had an issue where, you know, somebody didn't present and it was after the fact, and we are required to present offers until, you know, within 24 hours. We as agents are required. So Gary, if it's a multiple bid situation, are we not also still required regardless after final and best to deliver those, A? And why is it, doesn't, like you just said, it doesn't have to be a silent auction. Why isn't it that we could ask the listing agent to say, hey, if it's, you know, have you spoken to your sellers? Are they willing to reveal? It's your responsibility to get the highest possible price for your sellers. And if they are willing to reveal the numbers, then why not allow people to come in and say, yes, we'll match it, we'll beat it, well, whatever. Like, you know, highest and best doesn't have to be highest and best.
Ellen, it's a great question, and it's one that's very complicated to answer, but I'll do my best. First and foremost, you addressed a rule that is in fact correct. As listing agents, and let me just make sure that I make something clear, because this is something that sometimes licensees get a little confused about it. When I say the words listing agent, I'm talking about one person, and that person is the broker of record, Rob Lazard. No one else in the state of New Jersey with a real estate license is allowed to be an agent of a seller or a buyer except the broker. All the rest of us work as sub-agents of the broker. So we're talking about Rob's listings. So Rob is the one that makes these decisions ultimately, or through his office managers like Robert. But again, yes, the commission's rule says Rob is to make sure that all written offers are presented to his sellers within 24 hours, right up until the day a property either closes or expires and goes off and lists with somebody else. And you go, well, wait a minute, what if they're already out of attorney review and they're 2 days away from closing? Doesn't matter. The commission says unless the seller instructs you otherwise, we want the seller to see those offers so they can hang on to them as backups. And then there's a whole rule, Rule H in section 6.4, that deals with how you handle backup offers.
So how would you handle the fact that in these multiple offer situations, and it's happened to many of us, my agents, that the listing agent is saying, final and best, we're done, we're going into attorney review, or we're in attorney review, and my agents are being turned away with their offers. We're asking for these sellers' attorney's information, they won't disclose that. Now my agents have offers for their buyers that on a property that is yet to come out of attorney review, and we can't present.
Well, again, a couple things. It's a little complicated, but
We can hear you, Gary.
I said a couple things. It's a little complicated, but I'll try to go through each point you just made. Again, the seller's in the driver's seat. So if the seller's instructing the listing agent that, okay, we're done, I don't want to see any more offers, even though I have the right to, the commission says those instructions have to be in writing, have to be attached to the listing contract as an addendum, and you must be able to be shown a copy of those. And if you're not, then they're violating the commission regulations. But if they say, hey, here's the seller's email to me saying no more offers, then unfortunately that's the way it is, and the seller has the right to say that. But in terms of the offers that occur after that meeting of the minds, again, the commission says unless the seller instructs us in writing not to, we show them everything right up until the day their house closes or the listing expires and they go list with someone else. So they have the right to consider those offers as backup offers. So again, it's the seller that has to drive that process. The instructions have to be in writing, and the commission is very clear that you have the right to see those instructions in writing. In fact, interestingly enough, the the National Association of Realtors amended the Code of Ethics twice. In January of 2021, they adopted an amendment, and I have to, again, you'll forgive me, I don't memorize, but I don't want to give you the wrong citation.
Couldn't you just put the property in like pending after you get, like you say a limit of 5 offers, you just put the house in pending or put it temporarily off the market or something to that effect where you can stop the offers from coming in?
Well, again, that would be
instructed by your seller.
Right, instructed by your sellers.
Because some of these agents have like 14 offers. And that's gotta drive you out of your mind.
Yeah, I'm
It's gotta be
sure.
crazy.
So here it is, and Rob, if you got your pen, write this down. It's standard of practice 1-7 and standard of practice 1-8. The National Association of Realtors was getting so many complaints about this and the subject of whether or not a buyer's offer even got presented, that they added a sentence to 1-7 that says this: upon the written request of a cooperating broker who submits an offer to the listing broker shall provide as soon as practical a written affirmation to the cooperating broker stating that their offer has been submitted to the seller landlord, or a written notification that the seller landlord has waived the obligation to have the offer presented. So failure to give you that written affirmation is now a violation of the code. And they made that change in 2021. And then they decided this year, it took effect January 1st of this year, they put the exact same sentence in standard of practice 1-8 that says this: upon the written request of the listing broker who submits a counter offer to the buyer or tenant broker, the buyer or tenant broker shall provide as soon as practical a written affirmation to the listing broker stating that their counter offer has been submitted to the buyer tenants, or a written notification that buyer tenants have waived the obligation to have the counter offer presented. So now you've got two venues to go to: the commission regulation and the code of ethics, which has been modified to address that issue of, did my offer get presented or not? And if not, why not?
Okay.
So for a listing agent to say, you know, we're not presenting it, we're done, is unethical and illegal now. And if you ask a listing agent to say, you know, would you ask your buyers, would you ask your sellers to, if they would reveal, and the listing agent says, you know, we don't do business that way, that's not the way we do business, then you have to say, then I want to see it in writing from your sellers that that's the way you're choosing to do business. It's not your choice, it's your seller's choice, because then they're under advisement of their agent, their listing agent, but it's at least coming from the seller. Is that correct?
Yep, it is, Ellen. You've got it pretty much hammered. It's the seller that's in the driver's seat regarding this, and those instructions from the sellers. You always say to the seller, fine, if you want me to do it that way, shoot me a quick email. Then you redact their email address, but you can make a copy of the email saying, here's my written instructions, not to show any more offers to the seller, or not to show offers to the seller now that we're out of attorney review, or whatever the seller has directed us to do one way or the other.
In Florida, it's in our listing agreement that once the sellers accepted a contract, that they can check that they do not want to receive any more offers.
Yeah, exactly.
So Gary,
And I will say one more time, Florida is neat because it's what's called a statutory real estate regulation state, in that they've written a thorough bunch of rules, regulations, policies, and procedures. In New Jersey, most of our stuff comes out of common law decisions in the courts.
So Gary, if I'm the listing agent or sub-agent, as you put it, in one of the offices, I have 3 people that want to make offers on my own listing. Is it advisable, in your opinion, as a best practice, to have like a manager consult with them, or give me your insight into how to address that issue where you're treating everybody fairly and conforming to statutory and NAR guidelines? You're on mute, I guess, Gary. We can't hear you. We still can't hear you. Can't hear you. Let's see. I'm going to mute and unmute you, Gary. Maybe you disconnected the microphone, or...
Can you hear me now, Rob?
Yes,
Yes.
perfect.
Okay. It's saying my internet connection's unstable. I don't know why that would be the case, but I apologize. Refresh my memory. We were just talking.
So the question is, an agent in one of the offices is representing a seller,
Right.
and they get
Got
3
offers
offers
of your own.
Yep.
Right.
We can't hear you. We can't hear you again.
Is there a way to refresh, Rob? Can you hear me?
Maybe
Now we can hear you.
maybe if you turn off your camera, your resources will be better on the audio for now.
Sure. How's the audio now?
Perfect.
Good.
So you don't have to look at my ugly mug. This is a question that has a very complicated answer. I'll try to keep it short and sweet, but it's tough. I just said to you earlier that in New Jersey, only a person with a broker's license can be an agent of a buyer or a seller. Everybody else are what is called subagents. And New Jersey is one of 9 states left that operates with what's called blanket subagency, which simply means that when Rob accepts a listing or a buyer representation agreement from Robert, let's say, and makes Robert a subagent of that particular client, everybody in the company is a subagent of that client, whether they know it or not. So in the circumstance that you just shared with me, Robert, you could bring in the manager, you could bring in another agent, you could bring in yourself to consult with the different buyers, but the danger in that is that the buyers make the assumption that the reason these people were brought in was that they're representing them and not the seller, and the truth is that's not true. Under blanket subagency, everybody in your company is a subagent of both the seller and the buyer, so that you're all dual agents and you better be following the rules for dual agency. The system that you're talking about actually exists, and right now, let me do the math. There's 11 states that prohibit dual agency under any circumstances at all, and 9 states which still practice this convoluted blanket subagency way. So there's 30 states out there that practice a form of dual agency called designated agency. And so that allows the broker to designate one person to be the subagent of each client. So in that example, Rob, you could say, all right, for buyer B, I'm going to designate Robert Garber to be the buyer subagent. They'll take care of that buyer. For buyer B, I'm going to make Colleen the subagent for buyer B. And for buyer C, I'm going to make Judy Smith the agent. So each one of those agents are still full single agents to their respective buyers. You, the broker, remain a dual agent, and I always say it's kind of like watching a boxing match where Rob is the guy in the middle of the ring wearing the black and white striped shirt, and then all the agents come out when the bell rings and they fight like crazy to get the best deal for their buyers or sellers, and that's fine, and Rob's job is to make sure that they fight fair. So that's a special form of representation called designated agency that is not legally recognized in New Jersey yet. Again, not to take you way off tangent here, but when I was state president in 2012, this was something that was very near and dear to my heart because I knew we had a lot of brokers out there that had a policy that said if you had your own buyer and your own seller, we would bring in someone else to take care of one or the other. And that's designated agency, and that wasn't legal in New Jersey and still isn't to this day. So I've made it my personal crusade as the state president to try and get New Jersey to switch over. The last state to switch over to designated agency was our friends in New York back in 2005. And we have been working with the commission since then, and we are still working with the commission, and we get closer every single day to the day when I believe the commission is going to rewrite our rules and allow our brokers to practice designated agency. And then, Rob, what you would do in that circumstance is you would assign one of your agents to each of those 3 buyers, and they would be the designated agent for that particular buyer. Nobody else in your company would have that relationship, and they would be functioning as single agents, which means they could give full representation services to their particular buyer, and you would remain the dual agent. But right now I mean, you can bring in other people, but the danger is you give those buyers the impression that that person's brought in to take care of me. And the truth of the matter is, no, that person's just as much a dual agent as the original licensee who brought in all 3 buyers.
So you, you're not a fan of that practice for the appearance that they're represented when they're agency-wide, not they're still a dual agent. Now, would that practice be considered a violation of state law to do it like that, even if we say we're still a dual agent?
Yeah, I want to correct what you just said. I am a huge fan of designated agency. What I'm afraid of, and what I've actually testified, I've been before the commission on behalf of the New Jersey Realtors several times. what I've testified is, what I fear is that we have brokers out there that are practicing designated agency right now, and you, Mr. and Mrs. Commissioners, know that that's not a recognized form of practice in our state. And if something comes before you, you're compelled to follow the law as it exists now. Even though all of you know that designated agency exists, we're surrounded by designated agency states. New York, as I said, went over in 2005. Connecticut, Pennsylvania's been a designated agency state for probably 30 years. Delaware, and we've given models of their ordinances to the New Jersey Real Estate Commission. Says this is all we have to do to change in our rules to make this possible. So we know you commissioners know it exists, but until it's firmly adopted, you guys would have to follow the law, and one of our members might get fined or get in trouble because they were doing something that they knew was a safer practice, but you guys don't recognize it.
Gotcha. So let me rephrase it. I know you're a fan of the changing of the law, but as it stands right now, we put ourselves at risk by having 3 separate agents within the brokerage write up those offers because we might be misleading the purchaser.
Yeah, and that scares me more because of the potential liability in court, because the courts in New Jersey hold dual agents to a standard called impartiality. Probably the largest award in the real estate industry history was the Edina versus Bukuski case way back in 1995, where this single young lady named Miss Bukuski was trying to buy a house through an Edina realty agent. Edina was a huge company with multiple offices, and she ended up pursuing an Edina listing that was listed by some other Edina agent. Well, back in the early 90s, Michigan wasn't a designated agency state. It is today, but it wasn't then. So both the agent that had the listing and the agent that was working with Miss Bukuski were dual and should have been impartial towards the 2 parties to the transaction. But the listing agent, for some reason, either hadn't been trained, forgot, wasn't properly supervised. She did her best to try and advocate for her seller, which is what an agent does, and try to get her seller the best possible deal at Miss Bukuski's expense. When it all came out in the wash, Miss Bukuski got herself some very good lawyers. They established it as a landmark case, which meant that they were defending all of the buyers that may have worked with Edina and been damaged in the way that Miss Bukuski was. The original filing amount was $200 million, and we're talking early 1990s. That's boatloads of money today. And nobody knows for certain because it was settled out of court in secret. But the rumors are that Edina ended up paying close to $100 million to keep themselves from having to go through a trial over that. So it wasn't very long after that, obviously, that the Michigan State Association petitioned and got the state changed to designated realtor state, designated agency state, I should say.
Fantastic. A couple other, and Gary, I know we're on like overtime here. Do you have another 5 or 10 minutes for us?
I do, absolutely.
Okay. Question is variable commissions when we or another brokerage is taking less themselves. Is it they just check the box, or do they have to disclose what that arrangement is?
That's a great question. You if it's part of the original listing agreement, okay, and so you said as broker to the seller, look, if you list with us, we normally charge, and since we're all the same company, I can use numbers. We normally charge, let's say 6%, and we give 3% out to a cooperating broker. But if one of our agents, we're a big successful company, if one of our agents finds the buyer and I, the broker, don't have to pay out that 3%, then if you take that deal, we'll only charge you 5%. So there's a 1% differential. That has to be checked off because that was a condition of getting the listing. And if you're asked by the buyer's agent whether what the differential is, then the code of ethics comes under the code of ethics, says that we are to disclose that the variable rate commission. Let me back up and say it correctly. I screwed that up. If there are offers in place and the buyer's agent says, are any of these other offers from your company, and therefore the variable rate commission is in place, you are required to answer If the seller's given you approval to tell about other offers, you're required to answer about the variable. And if it does have a variable, you are required to answer, if asked, what the variation is, the deviation between the fee that you charge versus the fee you're charging for doing the deal yourself. So it's all, that one's all in the code of ethics.
Gotcha. Another quick question. Like a multi-state, we had somebody who had there was a listing that was put into a service called My State MLS. The agent that had that listing was not a member of the local MLS, but their brokerage was. This listing was not put into this listing was not put into the local MLS. I don't think it was required. And they said we don't cooperate. We have is an exclusive listing. You have any comment on that?
Yeah, that's one of those crazy situations. It's hard to figure out how to answer that, because obviously the seller, well, I shouldn't say obviously, theoretically, the seller was aware that you were putting the listing in that service that was going to distribute it to other states. But again, the argument could be that, yeah, but the leads come through to our company, so we're being true to the waiver of broker cooperation, but those leads are only coming through our company. And so because we have the waiver of cooperation signed, now here's the other thing, Rob, we have to be careful of. You guys, I'm sure, are familiar with the fact that the National adopted something called the Clear Cooperation Policy 2 years ago. And so realtor-owned MLSs require that if you have an exclusive under a waiver of cooperation, that listing still must appear in the MLS so that buyers, agents can at least give information about it to their clients, even though they're not allowed to cooperate on it. Now, those realtor-owned MLSs have to put that policy in place, and they have, and there are fines for violating it. Garden State is a privately owned MLS, and they chose not to follow that particular suggestion of NAR, so we don't have to do the clear cooperation thing. So you can have an exclusive that's not in Garden State, not be in violation of the Garden State rules or the national rules, because Garden State's privately owned.
Okay, so that's a complicated question. And two fringe questions here. I was approached by a licensed home improvement individual who's looking to get their real estate license and then promote that they would do work themselves on a home in advance of or as a value proposition to secure a listing. Okay. There's a lot of complexities here, which makes the attorney in me cringe. But do you see any other inherent risks other than attorneys salivating?
I do, because the commission says in our advertising rules, paragraph M, we're allowed to offer free, discounted, or whatever services. So this contractor could say, hey, I'll do this kind of contract and I'll discount it for 20%. But the commission says that offer has to be separate from the person having to do any business. So the contractor couldn't say, if you list with me. You follow? In other words,
so this was like a parroting of like the Compass. Hey, if you list with us, we'll give you a home improvement loan.
Again, I have heard of that, and I've discussed that with my friends down at the commission, and their attitude is that would not pass muster with the regulations. But of course, nobody apparently has filed a complaint against Compass about it yet.
So tying in, a loan to do home improvements in return for getting a listing would be a violation, just as if you're giving them a discount on buying it or letting them use your moving truck if you list with me, correct? Same premise.
It would be, in my opinion, a violation of the commission regulations. But the thing that would scare me even further is that the Antitrust Division of the Department of Justice of the United States government might consider it a tie-in sale, which is a violation of the Sherman Antitrust Act, and that can get you jail time.
So can you repeat that? That's so.
The Sherman Antitrust Act says it's illegal. It's an illegal restraint of trade to say to some consumer, if you want my services, let's say you want my services as a listing broker, you have to use me as your contractor if your house needs any repairs. And the person says, well, I already have my own contractor. I don't want to use you. Well, then you can't list with me. The Sherman Antitrust Act would call that an illegal tie-in of the contracting services with the listing services. It's a restraint of trade. And as I said, the Antitrust Act is a criminal law. It's overseen by the Department of Antitrust, the Antitrust Department of the Department of Justice, and you can do jail time for violating that law.
But that's only if you say you have to use them. If it's an option to use them, then it's not. Is that correct?
Yep, absolutely.
So Gary, in terms of like the conditioned upon, right? So Ellen hires a stager for $500 for all her listings, as well as a photographer, and obviously she's only going to pay for those services if we procure the listing. The distinction between that and, I'm going to, give you $2,000. I'm going to give you an interest-free loan for $2,000 to repair your front porch is significant.
I think so. The key with those kinds of things where, listing agents will say, well, look, I provide staging, or I provide, a home warranty, or whatever it may be. Again, it's dangerous. It's dangerously thin ice, because the commission typically is going to say, well, you can't say I provide a home warranty if you list with me, because that ties it into the listing. So it's no longer a true offer of a free service. What you could say is, I'll provide a home warranty to anybody who wants one, as long as you let me come out and do my listing presentation. And if you list with me, great. If you don't, you get a free home warranty for a year. So that would be the distinction that the commission would be looking at. It has to be a true free offering of a service, and it can't be tied into doing business with you. And it also, oh my gosh, can't involve any kind of a game of chance, lottery, or whatever. I'm doing a broker open house and I'm saying, hey, put your name in the jar, and whoever pulls it out, you get a this or you get a that. The commissions take a very dim view on that one.
I have a question regarding the staging, because I am a stager and I do staging for my clients. They don't have to use me. They can use me. I offer it. It's not like you have to use my staging services, but it's like I'm a stager. And if you want me to stage your house outside of a listing, I'll do it. But, if you want me to do it and I'm here, how do you distinguish that?
I think you would be fine if you said, look, guys, by the way, I happen to be a stager. I'm just picking a number, $500. If you have any interest, let me know. Otherwise, don't worry about it. It's got nothing to do with whether you list with me or not. Or the other thing you could do that the commission would have no problem with is you could say, hey, if you list with me, included in all the services I provide you, the exposure, the media, the this, the that, you get staging. Then it's
like staging is one of them.
But again, you wouldn't then be able to charge an additional fee. It would have to be built into the commission that you charged in the listing agreement.
Right, which is what I do. But if somebody wanted to, let's say, that wanted my staging services, but I really only want to work with people that are listing, that's my option of choosing to work with them or not.
Yeah, I think we're going down.
It's a slippery slope, but it's a real question. And I know that other people, have their other, services. So, or photographer or somebody like that. Like if you only want to work with people, how do you respond to that, Gary?
Again, I would say, you have to take your advice from Rob or Robert or whoever your manager is. They're responsible for you. If I was your manager, I'd say, look, if you want to just do your staging services for those people who list with you and you include it as part of the fee that I charge, I'm the broker, I make the decision about the fee. Let's say we charge 5%. And in your listing presentation, part of your value proposition is in our 5%, you get me as a stager. I think you're on okay ground, even if you don't use your staging services on the outside for someone else.
Okay, thank you, because that was my question.
Yeah, I
have a question. Robert,
Yeah.
Okay, I got a question. This is Robert Littman. If you represent the buyer and they're either doing a 203K loan, maybe FHA or none, or they're buying a 2-family, let's say, and it both, needs total renovation, and you say, look, I'm your agent, let's close, but if you want me to could work with you afterwards to manage the project, there will be a fee because I'm a busy person and I have no problem helping you, but there's going to be a charge for it after closing. Is that?
Well, again, I wouldn't see a problem with that as long as the fee was being paid to Rob, the broker, and he was paying you, because you can't be paid directly by the public for providing real estate services and property management.
But it's not, it's construction management services, and it's a completely separate transaction.
All right, if it's
after closing.
If it's construction management services after closing, that probably would not fall under the jurisdiction of the commission.
Yeah, I don't mean physically doing the work myself, but a lot of these people have no experience, and it takes months and months to do a project like this, and you want to charge for it.
Yeah, Robert, let's take that offline. We can do that. But my last question is, Gary, are you seeing any perils with the coming soon? The agent's use of coming soons?
Yeah, I am. In fact, I'm probably overstepping my bounds. So if you,
Gary, can you unmute yourself? I muted everybody just because of the background.
Can you hear me?
Yeah.
I just said I probably am. I'm going to share a little information with you, a little inside information. But if you tell anybody at the commission I did, I'm going to call you all liars. But I know for a fact that the commission has appointed a work group of investigators that are looking into 3 issues that they're really, really upset about because they feel they're being tremendously abused. One of those is the coming soons. Another one is teams and how they advertise themselves in a way that makes it appear as though they're the brokerage and not the brokerage. And finally, multiple offers. So they've got a task force that's working on this, and I believe it's the executive director's intent to really start to focus on these 3 issues because it's like Wild West City out there from the commission's perspective.
Fantastic. Well, if there's no other last second questions, I want to thank Gary. If you want to,
Rob, I wanted to do one thing for you on a positive note. So this should make you all very happy.
Thank you.
For the longest time, New Jersey commission regulations have prohibited licensees from forming LLCs and having their broker pay their LLCs their commissions, and then their LLCs pay them. Because the commission rule was if the broker is paying somebody, that person they're paying must also have a broker's license. So licensees would have to put up LLC together, hire a broker in order to do that and take advantage of the tax benefits of being involved with the LLC. The New Jersey Realtors has in State Senator Digan, a real good friend, and he put a piece of legislation in play last year, and it has actually made it to the governor's desk and was signed into law. And once the commission puts the rule changes together and implements them, you will be allowed as a licensee to form an LLC. Rob will be allowed, and it does not have to have a brokerage license. Rob will be allowed to pay your commissions to your LLC, and your LLC will pay you whatever salary or compensation that you agree to be paid by your LLC. And your tax preparers can tell you what kinds of things that opens up for you to do to help with your taxes. Now, the only problem is it's law. It was signed by Governor Murphy last December, but it involves rewriting the commission regulations, and that procedure involves the commission writing them, which they haven't even started yet. Once they're written, they have to be presented out for public comment for 90 days. Once they come back from public comment, the commission has 60 days to incorporate anything into them that the public had to say, and then they get implemented. So in talking to my good friend Doug Thompson, who's the Vice President of Government Affairs down at the New Jersey Realtors, we probably will not be able to do this officially until the end of the year, hopefully in time for next tax season. But I think that's really, really good news because this gives you as licensees a lot more options in terms of how you handle your compensation and your taxes.
And Gary, on another similar note, there's been, I guess, some banter about either federally, I think it's a federal push to make real estate agents employees. Do you have any? Is that a federal?
No, that was Governor Murphy, who was looking to try and create ways to add revenue to the state's coffers. And so he was proposing to eliminate the IRS Section 530 protection from certain industries, which allows owners of businesses to have their workers work with them as independent contractors. He presented it as a way to try and protect the rights of people like Lyft drivers and Uber drivers who don't get any benefits, don't get any overtime, don't get paid minimum fair wages and that type of thing. But interestingly enough, when the bill came out, the list of industries he wanted removed in New Jersey from the IRS Section 530 included us. So the New Jersey Realtors marshaled their forces, the National Association of Realtors marshaled their forces, and we did get Governor Murphy to carve us out. So we still remain in Section 530. The only complicating problem is that there is currently a lawsuit that was filed by a group, filed on behalf of licensees by a group that claim these licensees have been treated like employees for years, making them come to meetings, making them do this, making them do that. And so they should in fact be paid like employees, overtime, holiday, matching, withholding benefits and all of this good stuff. And the bad news is the plaintiffs won in trial court. The judge said, I agree, they should be treated as employees. And when it went before the appellate court upheld the trial court. So now it's scheduled in, I think, 3 months to be before the New Jersey Supreme Court. Rob, you know Barry Goodman as well as I do. He's argued before the Supreme Court many times, so I'm confident he'll do a great job. And we've gotten some legal help from NAR and some money from NAR. And we're very, very hopeful that when it gets before the Supreme Court, we're going to look. The governor just made sure we remained in that Section 530 protection. So we think this lawsuit is without merit and should be overturned. And we're hopeful that the justices will look at what the governor did and say, well, clearly.
Oh, we lost you, Gary. Gary?
Yeah.
Oh, you're back now. We lost you for a moment.
All right. We're hoping the state Supreme Court will say clearly the intent of the legislature is for the real estate industry to be part of Section 530 and the brokers be able to work with their agents as independent contractors. So we're hopeful that we're going to prevail in court. We have prevailed politically, but it's still up in the air a little bit, and that's at the state level.
Are there any states that require agents to be treated as employees that you're aware of?
Not yet.
Fantastic. Well, Gary,
there were 3 other lawsuits involving various states where the real estate industry prevailed. That's why NAR is taking such an interest in this case with us, because they don't want to see a domino fall, because once one falls, then they're afraid that a lot of them are going to fall. And I think that would be just an absolute paradigm shift for our industry if brokers like you, Rob, could no longer affiliate with your agents as independent contractors. You'd have to hire them, pay them benefits, follow the Federal Fair Labor Standards Act with all the things you do with them and that type of thing. It would, you know full well, it would change your business dramatically.
Yeah, and everybody else is in the industry.
Oh,
so
no kidding.
Gary, I want to thank you. This has been a fantastic event, and I'm sure everybody got a lot of benefit from it. Yes, it is recorded. It's recorded. It will be put up on our site. Thanks, Gary.
I am more than you're more than welcome. You and Rob, you and I have known each other for years. You're a good man, and my friend Robert Garver is someone I'm so proud of because he's actually a graduate of one of my broker's classes. I won't tell him how long ago, Robert, because then they'd know how old we are. But I've known Robert for a lot of years since he came through my broker's class. So anytime I can help you guys out, just give me a call.
Thank you so much. Have a great weekend, everybody.